Joan, we will keep admitting folks. Why don't you go ahead and get us started?
Okay. Okay. Welcome to the League of Women Voters of Wisconsin's webinar on constitutional amendments that will be on the ballot the August 13th election. I'm Joan Schwarz, attorney and secretary of the board, and I want to personally thank the members of the State Committee on Impartial Justice for their research and organization for the webinar. Our Wisconsin Constitution was drafted in 1848. It's a framework for governance of the state, including provisions for the power and structures of state government and for limitations on the state government, as well as provisions for individual and civil rights. It was never meant to be amended to implement current social or cultural policies or partisan objectives. These constitutional amendments have the potential to end the executive branch's sole power since 1930 to execute all federal funds that come to Wisconsin and transfer that final authority to the legislature. Executive power in the state has had that power for 94 years. Slide 2, please. Two questions were sent to you right before the webinar. The questions, Molly, please. Thank you. These two questions were sent to you right before the webinar, and they'll be discussed pretty thoroughly tonight. These amendments will be discussed later in the webinar. And I just want to make certain that at this point, we talk about just one word in there, the last word in question 1, determine how money shall be appropriated. It's really important to distinguish that we are going to be talking about the federal funds that the executive branch has the power over, as distinguished from state funds, which I will briefly refer to. The legislature tried to get this, they actually passed a bill in 2023 in order to make this a bill that could be in place and put the governor in power. I mean, the legislature in power for the constitutional amendments. But he vetoed it. Governor Evers vetoed it in April of 2023. Frustrated by Governor Evers' veto, they decided to put it into a constitutional amendment. The 2-year process, the first year puts the question together, and then the second session, the second year, has the same amendment, then it's placed on the ballot. With the gerrymandered legislature in place at this point, it's not hard to figure out that it's just a rubber stamp for the second year when the amendment gets put on the ballot. And intentionally, they put these two ballot questions of real significance on the August primary election, primarily because that's the lowest turnout election in the state. Governor Evers, who is elected by all of us, took timely action during the pandemic when we received $6 billion from the federal government. Federal funds were promptly executed to businesses, farms, organizations, restaurants across 1,000 communities. Federal funds also went to education and Wisconsin schools to reopen safely and effectively. And emergency relief went to over 193,000 students. Monthly tax cuts went to families of over 1,056,000 children, and 7,000 child care programs were reopened again safely. Economic relief went to Wisconsin homeowners to assist with their mortgages and also to renters. Premiums for the average Wisconsin family of 4 were cut by $611 a month, and insulin prices plunged to $35 a month for those with diagnosed diabetes. And of course, there was so much more. In addition to all of that emergency federal funds that came into the state, non-emergency federal funds came in as well, and the governor executed those funds to Wisconsin agencies. Infrastructure received $1 billion. The Department of Revenue distributed money, federal funds to small businesses. The Department of Health and Human Services distributed funds to home and community-based service providers and local government grants. The Department of Agriculture distributed federal funds for products, food bank, consumers and farmers, as well as industry and tourism. The Department of Children and Families distributed money for childhood and education assistance and grants to child care providers. There were so many more agencies, of course, that received federal funds and distributed to Wisconsinites. We just cannot risk the legislature choosing to delay or deny these federal funds to Wisconsin based on their partisan interests and their partisan gridlock. We've already witnessed its withholding of already appropriated bipartisan state funds from the governor to distribute to Wisconsin. They have withheld opioid funds, major increases in state aid for special education, compensation for executive branch employees, hospital service grants to Western Wisconsin to help mitigate recent closure of hospitals. $125 million has been withheld for PFAS plant funding and other major environmental issues. Governor Evers sued the legislature for withholding these state funds, and he just prevailed last week in that lawsuit. He will be getting that money that's been already appropriated. This webinar will delve into the serious issues in this election. After the presentations, we'll have a question and answer period, and please put your questions in the chat. Next slide, the speakers, please. Okay, these speakers tonight are here to provide information to help us decide how to vote on the 2 questions. The advocacy campaign, the Vote No campaign, is the League's advocacy. Our 3 experts tonight are Professor Oldfather, Marquette Law School professor, who will discuss the separation of powers doctrine in Wisconsin. And Attorney Godar is from the State Democracy Research Institute, and she will be discussing the ambiguous language and incompleteness of the 2 questions on the ballot. Ambiguity and incompleteness have been hallmarks of all the constitutional amendments that have been placed on the ballot by the legislature, whether it was Marcy's Law, the Bail Amendments, or the banning private funding for election administration. The passage of these amendments with their ambiguous and incomplete language has led to a number of questions for clerks and others in the state, and some have ended up in court action. And then we have Attorney Bloechl-Anderson, who is from the Department of Administration, who will discuss the complex process of appropriating federal funds, working with the governor. After these presentations, we will then discuss the possible ramifications for Wisconsin if these 2 constitutional amendments. So we will begin tonight with Professor Oldfather. Thank you. Welcome.
Thank you, Joan. I have happily had a summer relatively free of Zoom, so I'm hoping that this all works as planned. So my role in this, and thanks again, Joan, thanks to the League, thanks to all of you watching for paying attention to this, which is the sort of thing that is both important and I think easy to overlook. My role in this is mostly to cover some of the basics, provide some background, set up things for the discussion that will follow. I'm going to repeat some of the things that Joan referred to, but I don't think that's bad. So a little bit of a, almost kind of a schoolhouse rock portion of the program here. I was at a presentation yesterday where some statistics were bandied about, including one that indicated that a substantial portion of U.S. citizens don't even know that their own states have separate constitutions as distinct from the U.S. Constitution. I'm sure that's not true of anybody who's on this webinar. Nonetheless, it does suggest that we ought not to take much of any of this for granted. And so I'm going to cover some basic stuff. So what constitutions do, of course, is they constitute or create governments. And in the U.S. system, states each have constitutions. They resemble in broad form the U.S. Constitution, which was itself based on some of the early state constitutions. And one of their key features is that they divide up the powers of government, right? The framers of the U.S. Constitution, of course, they had experience under a monarchy, which does not involve divided power. And one of the great frustrations was that when power is concentrated too much in one place, it can be too easily abused. And so one of the mechanisms adopted in constitutions in the U.S. is this sort of division of labor, right? So they all create these three familiar branches of government. There's the legislative branch. That's in Wisconsin, the Assembly and the Senate, and their power is to make law, right? The Supreme Court of Wisconsin just last Friday issued a decision that defined some of these concepts. And so what we have here is, the idea that the legislative power encompasses the ability to determine whether there shall be a law. Right? What should the law be? Should there be any limitations included in it, and so forth? But basically, that's their job, make the law. The executive branch in the federal government, that's the president. In the state governments, for the most part, that's the governor. The executive branch has the power to enforce the law, right? To effectuate the policies that have been enacted into law by the legislature, to decide when it is that the law should be enforced, how it should be enforced, and so forth. And then, of course, there's the judicial branch, which will probably get relatively less attention in tonight's discussion. But the judicial branch, is there to say what the law is in the context of applying the law in individual disputes. So, for example, the executive decides to bring some sort of enforcement action against someone. It ends up turning into a lawsuit. There's some lack of clarity concerning what the law means. That's up to the courts to figure out what exactly it is that the law covers and does not cover, and so forth. And these all, of course, involve what are familiarly referred to as checks and balances, right? The idea there being that each branch has the ability within limits to keep the other branches from getting out of control, so to speak, right? So if the legislature passes a bill, the governor can veto it and keep it from becoming a law. But if enough members of the legislature think, well, in fact, it should be a law, they can, of course, override the veto. The judiciary has the power to declare laws passed by the legislature or actions taken by the executive to be unconstitutional. And so there are all these ways in which the branches can influence one another in the exercise of their powers and keep the other branches from exercising too much power and perhaps abusing it. That's checks and balances. It's also useful, I think, to reflect a little bit on a distinction that is drawn in the Wisconsin state constitutional case law between core and shared powers, right? So the idea here is that when the powers are divided up, they can't be divided up completely. There's going to be some overlap. There are going to be some areas where things that multiple branches do look a little bit alike. So, for example, when the state judiciary interprets a statute that had previously been ambiguous or at least unclear, and gives it a defined meaning, in a sense, it's making law. In a sense, it's doing the thing that the legislature is supposed to be doing. But those are powers that are shared. So shared powers, the branches can influence one another by, in effect, exercising those powers, maybe not simultaneously, but certainly both to some degree. Core powers, by contrast, are the ones that belong solely to a single branch, right? So, for example, the legislature has as a core, the judiciary, has this core power to decide specific cases, and the legislature can't pass a law or otherwise attempt to compel a court to decide a specific dispute in a specific way. That's the court's job. The legislature's job is to pass general laws. And so in doing that, we have shared, because the legislature could, for example, tell the courts, look, these are the procedures that you're going to have to use in deciding cases. We're not telling you how to decide specific cases, but we are going to put some general rules of the road in place. That sort of thing tends to be okay. So the point being, again, that each of the branches is equipped with tools to keep the other in check, and in theory, there's this balance between them. And I'm going to have here a little bit of a visual aid. This As it turns out, I was earlier this summer in Dallas, Texas, and stopped by the George W. Bush Presidential Museum and Library. And they have this little exhibit that is a greatly simplified illustration of how the separation of powers is supposed to work. And so there's this sort of triangular plate that's balanced on some point in the middle, and it's meant to illustrate that if any one branch gets too much power, the balance gets thrown out of whack, and that's not how things are supposed to be. It's a little bit oversimplified, but it does illustrate the concept that all of these powers are supposed to exist in some sort of equilibrium relative to one another. Okay, so that brings us now to the more specific questions that are at issue in these two amendments that we're here to talk about tonight. Again, the Supreme Court last Friday gave us some useful guidance, useful definitions to work with here. One thing it told us was determinations of how to appropriate the state's money are squarely within the legislative power, right? Essentially saying appropriations are a core function of the legislature. But that doesn't answer all the questions that might arise. The governor, the executive branch, has the power to spend that money and has discretion with respect to how to spend that money that will vary depending upon just how precisely the legislature specifies what the appropriation is for. So let me give you a simplified example. Suppose the state legislature were to say, you know, the state needs a new state vehicle. We're going to appropriate money to purchase a new car for the state of Wisconsin. If that's what the appropriation is for, then the governor would have the discretion to decide what kind of car is the appropriate sort of car, and that would be fairly wide-ranging, as contrasted with a situation where the legislature were to say, state of Wisconsin needs a new Toyota Camry. Now the governor's discretion is cabined. Can't choose any vehicle, has to choose a Toyota Camry, although there would still, of course, be some discretion left with the governor to decide what color it would be, what sort of options it would have, and other features, and so forth. So the legislature does have the ability to rein in the discretion of the governor when it comes to the ways in which appropriated funds are used, but it has to do that through the lawmaking process. The governor has a voice in that process. The governor can exercise the veto power with respect to appropriation legislation. So why are we here? Why do we have these amendments? Well, Joan alluded to it at the beginning. It's this. Current Wisconsin statutory law authorizes the governor to receive federal funds on behalf of the state and really doesn't place much in the way of constraints on how it is that the governor uses those funds, right? And that's no surprise because that money will be given to the state, made available for a variety of purposes. It's impossible to specify in advance precisely what those might be. And so no surprise, there's kind of a general authorization there. Well, and again, as Joan mentioned, what happened during the pandemic was lots of federal money was made available to states. The governor took a lot of that money on behalf of the state of Wisconsin, used it in ways that the legislature didn't like, and didn't necessarily do it by consulting the legislature too closely. As you may recall, there wasn't exactly a warm relationship between the two sides at the time. He would presumably, and indeed, as Joan mentioned, already has vetoed any legislation that might be passed by the legislature proposing a change to this arrangement. And so the legislature said, well, we're not going to be able to change the law through the usual procedures, so let's do this. We are the entity that has authority under the state constitution for originating amendments to the state constitution. We'll do that. We'll amend the state constitution. That's a process that the governor does not have a role in, has no ability to veto. And so, in effect, the legislature is attempting to go around the governor directly to the people to amend the state constitution to give it power that it would not have been able to get, has not been able to get through ordinary legislation. That brings us to the two proposed amendments and also to the end of my portion of the program for now. And I will accordingly stop sharing and pause here.
Thank you very much, Professor Oldfather, for your overall view of how the separation of powers doctrine is relevant to the two questions on the August 13th ballot. We now welcome Attorney Godar from the State Democracy Research Institute.
Great, thank you. So first off, as Joan mentioned at the outset, I just have to include a disclaimer that I am not able to advocate one way or another on these amendments, but I'm just providing sort of general information about what they say and how they're interpreted and some general context for them. All right, so I also have not been using Zoom lately, so bear with me a second. So picking up where Professor Oldfather left off, these are what the constitutional amendments say. And before I sort of dig in more deeply on what this language means, I want to zoom out and talk a little bit about how and who decides what constitutional amendments mean. So looking at the April election administration amendments that were just passed in April is how we're going to think about this. And the one I want to focus on is the one providing that no individual other than an election official designated by law may perform any task in the conduct of any primary election or referendum. And so this passed in April, and before and after it passed, clerks had a lot of questions about what does this mean? Can we still work with vendors who aren't election officials to print ballots? Can we still work with law enforcement personnel or IT personnel who aren't election officials in various parts of the election administration process? So the question is then, who decides what this means? And the first layer is there are election clerks. They could all sort of decide by themselves how to interpret this. But as Scott McDonald, who's the Dane County clerk, has noted, we don't really want to have 72 or more different ways of doing things across the state. The second layer is the Wisconsin Elections Commission could do administrative rulemaking to really interpret constitutional provisions or statutory provisions, but that process takes a long time, often more than a year. Obviously, elections are coming up sooner than that. So the next layer we go to is the Wisconsin Attorney General, and clerks have asked the Wisconsin Attorney General to provide his opinion on what the constitutional provision means. And he did that, and importantly noted that it doesn't apply to those things that I was talking about, that election officials can still work with vendors for printing ballots, work with IT and law enforcement for those kinds of things. But this is not a definitive ruling about what the constitutional amendment means. It is helpful guidance, and clerks may follow it this fall. But if that clerk action is then challenged in court, we ultimately end up in the Wisconsin Supreme Court. And the Wisconsin Supreme Court has the final say on what a constitutional provision means. This is what the court has said about how it interprets constitutional amendments or other constitutional provisions, the purpose being to give effect to the intent of the framers and of the people who adopted it. And they look at three things when they're figuring out what that intent is. One is the plain meaning of the provision. The second is the constitutional debates and practice at the time, sort of what people understood this to mean. And then the third is the earliest interpretations of the provision by the legislature, as manifested in the first action that the legislature takes following adoption of the provision. And so I think this is something that people don't always expect, is that the legislature does not have the final word on what a constitutional amendment means. And so it often ends up in the hands of the court actually deciding what those words mean. That said, the legislature does have some potential role to play in this third piece by passing a law that shows sort of what their intent was or understanding of this provision was. But the court doesn't have to follow that. And so that's not always in harmony with one another. So given that context, jumping back to the August amendments, I want to talk a little bit about some of the ambiguities and uncertainties about what these mean. And I'm going to start with the second question. And as a spoiler, I will be asking more questions than answering them for you. So this first one is about the governor not allocating any federal monies the governor accepts on behalf of the state. So the first part I want to tease out is what money does the governor actually accept on behalf of the state? And looking at a couple examples in statute, this first one is very broad. It covers education, promotion of health, relief of indigency, promotion of agriculture, any purpose other than the administration of the tribal or any individual funds of Wisconsin Indians. The governor is authorized to accept those funds. And so there are a lot of funds that the governor accepts directly beyond the COVID relief that we were talking about as sort of the impetus for this constitutional amendment. That said, this doesn't apply to every federal dollar that comes into the state. This second statute here talks about a provision for the Board of Regents to directly accept money that goes to the University of Wisconsin system. And there's also similar provisions. Sometimes local governments or counties directly get money from the federal government, and this shouldn't affect those because the language says it deals with money the governor accepts on behalf of the state. But that leaves a lot of uncertainty about what this covers because, like I said, that is a lot of funding. And it raises a sort of second question, which is, what does it mean for the governor to allocate federal monies? And so again, looking at the COVID relief context, you can think about this as the legislature trying to go after large pools of funds that the governor is then deciding how to distribute. But there's a really open question of, does this apply to all federal funding that goes through the governor, including things that are already designated by the federal government for a specific project? So for example, a transportation project. The governor of Wisconsin and Minnesota recently got funding for, I think, a bridge. And if the federal government says, here's $1 million for that bridge, is the governor actually playing a role in allocating that money? And that's right now a pretty large unknown. So it's hard to know if this would only be funds that are more like the large pools of COVID relief, or if it would also be every type of funding that comes to the governor. And then the third question in this part of this amendment is what the legislative process would actually be. So it's pretty explicitly left open in the amendment of either the legislature can approve funding by joint resolution, where the Senate and the House each pass the same resolution, or as provided by legislative rule. And then there's no detail provided about what that process would be. The legislature has used the Joint Finance Committee, which is a legislative committee, to decide whether to approve funds or not for state funds. And that was originally talked about in this amendment, so that is another possibility for this. But I just want to contrast sort of that open-endedness of the constitutional amendment with other states that have this type of provision in statute. There are other states that have mechanisms for the legislature to review federal funding that goes to agencies. Minnesota is one. And this is a small portion of their statute about what that process looks like. And it details the review period, it details when the funds can be spent. If at the end of a regular session, the legislature does not act on the request, then the funds can be spent. And there are also exceptions, not on this page, but for emergency funding for sort of natural disaster type emergencies. And so there's a very detailed statutory scheme, and that's sort of an inherent limitation of constitutional amendments, is constitutions are typically not drafted with the same degree of detail as legislative statutes. So turning to the first question, this one has even more uncertainty about what exactly it would do or what it means. And that's because of a few things. The first is that it's not clear if this is talking about federal funding or state funding, because the legislature does have the power of appropriations in the state funding context. And then it's also not clear whether the legislature has the sole power to determine how money shall be appropriated, even in the state context. And so to unpack that a little bit, the Wisconsin Constitution provides that no money shall be paid out of the Treasury except in pursuance of an appropriation by law. And that lawmaking process involves the legislature, both houses, passing an appropriations bill. And then that bill is presented to the governor. The governor can either sign the bill, can veto it in full, or for appropriation bills, he can veto the bill in part. And so there already is sort of a shared aspect of determining appropriations between the legislature passing a bill and then the governor signing or partially vetoing that bill. And Professor Oldfather already touched on this a little bit, which is a case decided last week that determinations of how to appropriate the state's funds fall squarely within the legislative power, but the power to spend appropriated funds falls within the executive power. And so that really raises this question with regard to federal funds is, are they actually being appropriated by anyone in the state? Or is the federal government appropriating them to the state and then the executive is spending them? And so this just leaves open a lot of questions about what this provision would be interpreted to mean. And ultimately, the reason that I am not able to provide you a lot of answers today is that that will end up in the courts almost certainly, and it will be something that is ultimately decided by the courts. And so lastly, I just want to contrast sort of Wisconsin's ballot measure practice with some other states' practices around constitutional amendments, specifically California. California's Secretary of State, for any ballot measure constitutional amendment on the ballot, has to provide a voter information guide with all of this information in it. So it includes an official summary from the Attorney General, a summary from the legislative analyst, campaign finance disclosures, the legislative analyst's impartial analysis of the measure, arguments for and against the measure, and the voter bill of rights and the measure's full text. And so just as another example of a different way to do this, there are some states that provide sort of a lot more robust information around constitutional amendments. And it is, I would say, a downside of our current Wisconsin system is having pretty sparse information on some amendments and a lot of uncertainty going into voting. So it can be hard to figure out what exactly the provisions do until after they're enacted. And I will turn it back to Joan.
Thank you, Godar, for your complete analysis of what is problematic with the wording of the two constitutional amendments. Appreciate it. We now will hear from Attorney Bloechl-Anderson from the Department of Administration, and she will discuss the complex process that's involved in distributing the funds, federal funds. There we go. Thank you.
Thank you. As is on theme tonight, I also don't deal with Zoom a lot, so hopefully I can get this right for you. You can see my screen, correct, Joan?
Yes.
Great, great, okay. So I work for the Department of Administration. I'm a legal counsel there, and as Attorney Godar indicated, I'm here to provide factual information. I cannot advocate one way or the other. But that being said, the Department of Administration has quite a role in the distribution and administration of federal funds in Wisconsin. And I'm here to provide kind of a high-level overview of some of the ways that those federal funds come to the state. And then I'll focus specifically on how some of these federal COVID relief funds were distributed to Wisconsin, as well as administered by DOA and then other state agencies. So how funds become available in the state really depends on how the money flows into Wisconsin. And this includes formulaic allocations, competitive grants, and one-time emergency funding, some of which we just touched on here tonight. The proposed amendments refer to federal funds being accepted by the governor. And while the governor does have broad authority in this area, agencies also sometimes have independent authority to accept funds under state statute. And those sometimes, examples of this are the UW as well as Department of Transportation. For the formulaic allocations, depending on the program, this may require acceptance by the governor. However, federal program requirements will ultimately dictate spending. Apologies. Note, some of these funds will also be reflected in the biennial budget, and therefore they would be approved through the legislative process. For competitive grants, again, depending on the program, this might actually require acceptance by the governor. And the federal program requirements and the proposal's contents will dictate how that money is spent. For one-time emergency funding, these are funds whereby the state is given discretion, and they will likely be accepted and allocated by the governor under section 16.54 of the Wisconsin statutes, and that's been touched on here tonight as well by the other speakers. Note that FEMA, Federal Emergency Management Agency reimbursements are typically handled by the Wisconsin Emergency Management, and that's done under the Department of Military Affairs in Wisconsin. As I indicated above, the way that money flows through the state of Wisconsin is dependent on the funding source. And in the context of the pandemic response funding, various state agencies were involved in administering money. To use ARPA as an example, ARPA dedicated additional funding to existing federal programs run by the states, and this funding was administered by the state agency that was already receiving that money. ARPA dedicated funding to states as a whole, and the governor designated an agency, in this case DOA, to administer some of those funds. And those funds that were administered by DOA and are being administered include the coronavirus state and local fiscal recovery funds. ARPA created programs that allowed state to apply for additional funding via competitive grants. And I'll talk about that a little bit later on in the slide presentation. Those funds are actually administered by the grantee agency to which they were granted. So this graphic represents the allocation of all federal funds in Wisconsin since 2020 in response to the coronavirus pandemic. Critical investments were made to the state through the state's coronavirus relief fund, which is the CARES Act, and the state and local fiscal recovery fund, also known as ARPA. Other CARES Act and ARPA programs, as well as the Consolidated Appropriations Act and the Federal Emergency Management Agency Public Assistance Program, supplemented these funding sources. This is all one-time funding, otherwise what you would classify as an emergency funding. Some of this was allocated directly by Governor Evers. Some was allocated because the federal requirements dictated that these federal funds went to a specific purpose. So, for instance, rental assistance. So backing up to focus more specifically on ARPA, ARPA did include some programs administered by the federal government and some money dedicated to states for further disbursement. ARPA specifically focused on funding the ongoing public health response to the pandemic and addressing urgent economic needs as created by COVID-19. ARPA funding in Wisconsin went to the following types of initiatives, and this is a non-exhaustive list. However, as you can see, the initiatives are varied and numerous. Wisconsin received approximately $2.5 billion in SLFRF funds through the Department of Treasury, including direct funds to all levels of state government, tribal governments and territories, and non-entitlement communities, which the Department of Administration worked with the Department of Revenue to distribute. So once federal funds are received, the agencies have to put them into action. And DOA has done this with those SLFRF funds, as it's been tasked with administering them in the following ways. DOA administers several types of Wisconsin ARPA funds, including the SLFRF allocation. It obligates funds to other state agencies for programs that are directed by the governor via MOU and various initiatives. We have implemented various small business economic recovery grant programs, such as live music venues and hotels, et cetera. And there are also competitive grant programs that are targeting key areas through which the department administers. And those key areas are healthcare infrastructure, neighborhood investment fund grant programs, tourism capital grant programs, diverse business assistance, and diverse business investment grant programs. Those are all administered through the Department of Administration directly. The grant administration of all of these programs is robust, and it includes the selection processes and grantee risk assessments, executing of grant agreements, memorandums of understandings between state agencies and other entities. There's a lot that goes into the administration of just these grant programs. And my favorite part, compliance and reporting. State agencies, including the department, are tasked with monitoring the use of funds and reporting out in various ways. This includes financial monitoring, qualitative monitoring, which is more of a performance-based, treasury reporting, which happens quarterly financially, and annually based on performance, and then annual audits. So for financial monitoring, DOA and third-party contracted auditors test grantee expenditures for compliance with American Rescue Plan Act and grant agreement or memorandum of understanding requirements. Expenses have to be eligible and they have to be within the performance period of that contractual document. Financial monitoring is also performed on the Department of Administration's 6 competitive grant programs. Those are the ones that I just referred to previously. Those are largely advanced payment grant programs, although there is some reimbursement that looks back to the start of ARPA, which would be March 3rd, 2021. DOA also financially monitors the governor initiative allocations, and these are largely reimbursement-based. Qualitative monitoring consists of such things such as desk audits of payment request narratives. And what this means is when a grantee requests a payment through one of these competitive grant programs, it has to provide a narrative of project activities that they are doing and or engaging in. And they have to submit these documents called payment requests and semi-annual reports to the department. This qualitative monitoring also includes site visits, and that's to visit the project locations that the grantee indicates, perhaps they are building something or they are improving some sort of infrastructure. And department staff will go there and physically visit the site. Policy compliance reviews are also part of the qualitative monitoring. And what that is it reviews policies that are required, that grantees are required to have in place, such as procurement or conflict of interest policies, or things such as record retention policies, anything that is required of them in ARPA and or their grant agreement or memorandum of understanding with the department. There's also public information checks that are performed on grantees to ensure that grantees are not, for instance, suspended or debarred contractors, that they're not an ineligible vendor, that they're not tax delinquent, among many others. For the Treasury reports, as I said, these are performed both quarterly and annually. Part of this reporting process is quarterly reporting, where the department will gather financially focused information from all of the state agencies on all of their projects for the money that has gone to them through the department. And then once we receive that information, we report that back and reconcile that to the Department of Treasury. The department also gathers performance-based data from these agencies annually, and that is a description of what the funding is being used for, also reported to the Department of Treasury. Finally, annual audits are part of the compliance and reporting process that the department looks at. And ARPA grant agreements and memorandum of understanding have audit requirements in them that these SLFRF grantees are required to follow and submit that information to the Department of Administration for review. So as you can tell, the compliance and reporting is a very robust process, many robust processes that the Department of Administration handles while it administers these grants. And that's the conclusion of my presentation. If you have any questions, you can certainly go to Badger Bounce Back or the DOA home website to look for further grant information.
Thank you, Attorney Bloechl-Anderson. That was a very complex process that we probably all didn't know about. Okay, we're going to spend some time now talking about projections of what would happen if these constitutional amendments are voted in as yes to the constitutional amendment. Professor Oldfather, what concerns do you have about the separation of powers doctrine if these two amendments pass?
Sure. I mean, I think it certainly would shift the balance of power more towards the legislature. And, you know, I think it's useful to think about that not just in terms of the immediate questions that are presented, namely the allocation of federal funds, but it also gives the legislature an informal tool to use in negotiations as well, right? To be able to say, if the governor doesn't do this thing we like, we will exercise our authority with respect to federal monies differently than if the governor does do what we like. All of that, of course, depends on the political context, and you know, these provisions matter most in a world of a divided or very divided government. And we may not have that after the next round of elections, depending upon how the new maps leave things. But certainly, at least on paper, there's going to be a shift in the balance of power, and you know, it perhaps sets some sort of precedent in terms of making it more likely that people in the future will turn to constitutional amendments to make changes that perhaps ought more properly to be done through ordinary legislation. That's certainly a thing that has happened here before and has happened in lots of other states, but probably something that we don't want to have become too commonplace. So, you know, I think as with a lot of this, the answer to the question is a little bit unknown and a little bit it depends, but certainly the framework would shift the overall balance of power more toward the legislature than has been the case.
Okay, thank you. Attorney Godar, what concerns do you have if the voters split their votes between questions 1 and 2, which they have done in past constitutional amendments? They have split their votes, which was not necessarily anticipated. So if you could explain a little bit, that would be helpful.
Yes, so I think if question 2 passes, which is the one about the governor not allocating federal money without legislative approval, I think that passing will have a lot of the impact that the legislature has said it wants to have with these amendments, which is having legislative involvement in the federal funding process. What is much less clear is what will happen if the first question passes about the legislature not being allowed to delegate its power of determining how monies are appropriated. That wouldn't necessarily touch on the federal funding question. For the reasons that I talked about, it's not clear that the legislature is the one appropriating that money. That is a term that is used sort of very specifically in the budgeting and legislative context. And that said, I think there would be people arguing that it would still do that. And so I think if the first question passes, we're just going to end up in court a lot faster than if both or the second one passes. And it really sort of remains to be seen what that amendment would do.
Okay. What ramifications do you see for federal funding if the vote is split? How do you see this playing out besides going into court? I mean, who would then have the authority?
Well, so I mean, again, if question 2 passes, I think that accomplishes the legislative review of federal funding by itself. If question 1 passes, there's an argument that it doesn't touch on federal funding at all. But again, it sort of goes to a lot of the uncertainty here where there would the two sides would basically be arguing either this does impact federal funding in the way that we wanted both amendments to impact it, or that it just doesn't even touch federal funding and doesn't really change the balance of power. And that's just sort of a toss-up and depends. We have another election coming up also on the court next year. It really depends on sort of who that goes before, who's making the arguments and what that court looks like.
I have a question about question 1. The way it's worded, it really isn't true, is it? It's very, when it says delegation of appropriation powers, so that the Constitution is be created to provide that the legislature may delegate its sole power to determine how money shall be appropriated. It's not making clear what which monies they're talking about. Is that correct?
Yes, definitely. And that's where a lot of the ambiguity is does the legislature have a sole power over appropriations, and what is that sole power? And there is a good case that the legislature has extensive power over state appropriations as provided in the Constitution, and including the governor as part of that with the veto process. But the legislature does, and the Wisconsin Supreme Court just reaffirmed that the legislature has a lot of power over how to appropriate state monies. What is not clear and what hasn't been fully litigated or fleshed out is what power the legislature has over appropriating federal monies. It's not clear whether they do have that power. Currently, they have delegated that power, and not even that power, they've delegated the power to accept federal funds to the governor, and the legislature can presumably accept federal funds. What is less clear is what role the legislature plays in appropriating. And I recognize I'm getting a little bit into the weeds there on interpretation, but there's just a lot of ambiguity in that amendment and a lot of varying interpretations of what that could mean. And that's where the difficulty with not having that elaborated on means that voters don't really know what they're necessarily voting on, because the meaning of it will ultimately be determined in court after the amendment is part of the Constitution.
Thank you. I appreciate those answers. And Attorney Bloechl-Anderson, I understand that there are contracts with the Wisconsin agencies, and what kinds of consequences could occur with the contracts that the Department of Administration has with agencies, municipalities, if the legislature has the power to appropriate those federal funds? Can you explain a little bit about those contracts?
Sure. Just to back up a little bit, there are contracts between the Department of Administration and state agencies, which are MOUs, as well as contracts, contractual instruments between the Department of Administration and grantees that are competitive grant awardees, I'll call them. It's very technical. I don't want to get into their designation, but so the amendment should be forward-looking only. So existing contracts in theory shouldn't be impacted, but future contracts could be impacted depending on the source of the federal funding. So for instance, if there was another emergency funding or a one-time funding that was passed, like we saw in the stimulus or with ARPA, those could result in legislative approval being required before the governor could allocate any of those emergency funds. So again, it kind of depends on the source of the federal funding.
Okay. And is it a potential ramification that there could be denials or delays in appropriating federal funds if the final power is removed from the governor and moved to the legislature?
Yeah, and so as my colleagues have indicated here, it's difficult to predict, right? If there's going to be denials, if the legislature is inserted into the process, it would certainly depend on the situation. However, delays are certainly possible. It also depends on how the legislature proposes to implement the amendments. We don't know what that's going to look like right now. They have made statements that they don't believe that it's going to apply to every federal grant, but they haven't indicated what a joint resolution or some sort of rule would look like or what that would include. So again, not to be too ambiguous, but the answer is, we're not sure. But we do know that in general, adding the legislature into any sort of process is going to add time. And time means impact. So the way the legislature and its committees currently meet, it's not set up to be responsive or particularly fast moving. So at the very least, what I can say is that if these constitutional amendments pass, the legislature is certainly going to need to be prepared to be more responsive.
Okay, thank you. So there's even ambiguity then in the second question about the joint resolution or the rule making. Again, that's if we have not been provided. Okay, well, I appreciate those comments very much. All right, we are going to now shift to Molly Carmichael, who is the communications manager for the League of Women Voters for Wisconsin, and she's going to talk to us about some of the actions we can all take to make certain these constitutional amendments are clear to everybody and help us in terms of how we're going to vote for this. Molly?
Great, thank you, Joan. Can everyone see my screen okay?
Mm-hmm.
All right, awesome. Well, thank you all for joining us on this Wednesday. As Joan mentioned, we are going to dig in a little bit to the resources that the League has available, some of the actions you can take to get some of those vote no messages out of this space and into your community, into your networks. And we're going to do kind of like a little mini volunteer action thing while we're all here together. So first up, I just want to touch on the toolkit, which is something that the League and our partners put together ahead of the August 13th elections to help inform voters about these constitutional amendment questions and, urge folks to vote no on both of them. So this toolkit was included in the email provided to you before this webinar. It's on our website and we'll send it to you again. So no worries about getting any of these resources. We'll make sure it gets into your hands. So the toolkit is definitely longer than one page, but we only have one page up here on the screen. So it has some of the main takeaways about, baseline, here's what these questions mean, here's what a yes vote means, here's what a no vote means, just to kind of, obviously reading them, they can seem quite daunting. At least that's how I felt. So just trying to break it down, make it a bit more digestible. We also have messaging in English and Spanish. And so again, this messaging is just using, values-based messaging about things that Wisconsinites care about and tying it into why you should vote no. So this could be useful on social media. This could be useful in conversations with friends. And again, we have points in English and Spanish. We also have content to share. So I'll start by talking about the digital content we have that can be used on social media. And we encourage everyone here to post on their personal social media accounts. The league and our partners, we're always posting on our organizational accounts, but it's always great to kind of, get out of the echo chamber and reach new audiences. And people tend to trust their friends, which we will get into a little bit more later. So there's videos, there's images, whether you use Facebook, going into a Facebook group is, again, always a great way to reach a new audience. I know I've posted in, neighborhood Facebook groups I'm in and whatnot. Instagram, Twitter, LinkedIn, why not? I know Nextdoor has been really useful for some folks. Some league members have really taken advantage of using Nextdoor and have gotten good responses because a lot of times there are folks who, might think this is an election they could sit out. There isn't anything of note on their ballot. Maybe they don't even know there's an election or constitutional amendment questions. So just, getting that information out there and being kind of a point person for your networks is really helpful. And then the toolkit also has some actions that you can take ahead of the August 13th election. So, we have some flyers, so you can hang up at your church, at your place of work. I know I've brought some voting information to hang up at the corkboard at my yoga studio. We have a speaker request form. So if you have, an extracurricular group that you want to bring someone in to talk a bit about our Vote No campaign and a bit more about these questions, that is an option. We also have quite a few letter to the editor templates. So if you're looking to get some information in your local paper, please do use those templates, and we're always available to help get things placed. And there's a few other actions as well in there included in the toolkit. And like I said, we will make this toolkit very available to everyone here, but if anyone wants to just scan this real quick and pull it up on their phones to take a look, now's the time. And we always have all of our information, all of our resources at lwvwi.org under the fittingly named Toolkits and Resources tab in our menu. So like I said earlier, oftentimes our friends are very trusted sources of information, and assuming, you all are here on a Wednesday evening and coming to get this information, really dig into these questions, I'm going to assume a lot of you, like me, are kind of the go-to person in the friend group. Maybe getting a text the day of the election, like, what do I need to know? What do I need to bring? What do I need to do? And so, again, we're just going to take some time to make sure all of our friends, family, people we're just in group chats with are informed about these questions and at least know where they can go to get more information. So we're going to do something called a friend bank. I'm sure a lot of folks here have maybe done a friend bank or have maybe done a text bank where they're texting, off like an anonymous number to numbers they don't personally know. I'm sure everyone here has received many texts from text banks about issues, candidates, upcoming elections. Friend banks are a little cozier because you are texting people that you know, so you are much more likely to get a response, and they are much more likely to take you up on getting more information. So we just have a list of, ideas to kind of get you inspired here: spouse, good friend, neighbor, neighborhood group chat, recent graduate who maybe also needs to register to vote. So, if this is something you're feeling nervous about, it's always good to, maybe start with your good friend, someone you feel close with, and then kind of work your way up into texting that big group chat and making sure everyone there knows to vote no. So we're going to actually put a script in the chat here that you can use for friend banking. You don't have to use the script, of course. You can use whatever information you want about these amendments. You can just shoot someone a text and ask them if they know about the upcoming election. Really whatever way you want to approach it, but we do want to offer up this script as a way to just make it easier to copy and paste. And we're just going to take like 2-3 minutes. I'm going to attempt to play a song so you don't all just sit here and listen to me breathe. And we'll just text our friends about these constitutional amendments and voting no, and then we'll regroup and we can try to gauge how many people we reached all together in just a few minutes. So we'll get that script in the chat and we'll get texting.
Thanks, Molly. Hi, everybody. This is Delaney from the state office as well. Just want to give you a little pep talk for the Friend Bank. This is my favorite activity of the election season. I love to text friends and family members about the election. So many of them are totally unaware that these important constitutional amendments are going to be on the ballot. And like Molly said, this type of relational organizing with folks that you know is the best way to get people to turn out to vote, get people educated on who's on their ballot, what's going to be on their ballot. They're more likely to hear you out. Take some time to look at the links that you're sending, send them the toolkit, send them our resources. They're going to be much more likely to listen to you than some random person from an automated text bank. So this is a great opportunity to get some other people really hyped up about these amendments so we can all turn out and vote no.
I feel the earth move on the moon. I feel the sky.
Okay, it looks like the music's working. Some people are bopping their heads. So we will, let's take a minute or two. Thanks for the pep talk, Delaney.
I feel mellow as the month of May. Can't stand it when you look at me that way. Hey, I feel move on the moon. I feel the sky down the moon. I feel my heart start to tremble whenever you. You're near me, and you tenderly call my name. Emotions are something I just can't tame.
Okay. Sorry if the music was choppy, everyone. Hopefully better than silence still. I'll just take a minute or two and see if anyone wants to put any updates in the chat about, how many people you texted, if anyone wants to come off mute real quick and, if anyone got an interesting response they want to share.
I texted a friend who recently moved. The deadline to register to vote online for the August 13th election is quickly approaching on the 24th. So I reminded her that she's got to get registered and also made sure that she was aware that these two dangerous constitutional amendments, like Tracy said in the chat, are going to be on the ballot. I appreciate that edit, Tracy. Dangerous is a great synonym to put there.
Music to my ears. Thank you. Awesome. Exit book club. Great. Thank you all. All right.
Someone put in the chat that they texted to their book club.
I love that.
Yeah, that's good.
I'll just say thank you all for your time and attention and for taking an action. And again, everything's on the league website. And remember to vote no on both questions. Thank you.
Thank you, Molly and Delaney. We appreciate all that information. Okay, at this point, we are going into question and answer period from your questions that you've been putting in the chat. Joy Cardane, a member of the league, has been monitoring the chat, and she will now take some questions for our experts, and we'll move forward. Thank you, Joy.
Thanks very much, Joan. Thank you. Lots of good questions in our chat. And before Molly goes away, I'm going to start with one question for the league. Some of the league questions have been answered in chat as well, but somebody said it's the League of Women Voters says vote no on these amendments. What groups are saying vote yes?
I know there are some legislators who are saying vote yes, because of course they passed it. Some other organizations, I can't think of any off the top of my head. But yes, I was just about to say it is listed in Ballotpedia. So when an organization publicly says yes or no to these questions, they can get listed in Ballotpedia. And Eileen kindly put the links in the chat. So last I looked, I don't remember if there were any organizations listed, but that might have been a while ago.
That's okay. Thanks. Yeah, I've seen the answer being the Republicans in the state legislature, and not a lot of groups that are saying vote yes. Well, we have a lot of questions, and it's I guess I'm going to try to direct these to our experts the best I can. There was some questions about the federal funding, so I think I'll direct these to Stephanie. One question is, if the amendments are passed, how would they impact the unresolved issue of Medicaid expansion? Are you able to answer that, Stephanie?
Well, my understanding is that Medicaid expansion is both federally and state funded. That's my understanding. I'm certainly not a Medicaid expert, but it would depend on, the sourcing of the funding, right? So if the legislature has any sort of say in it, then they would have a say over potentially the Medicaid, the funding there on that side. I'm certainly not a Medicaid expert though, but again, it would go back to the type of the federal funding, the source, and then who decides at that point.
Another question that perhaps you can start with, and if other speakers want to weigh in, just please jump in. If the legislature takes over federal funding, how will they acquire the necessary staffing to do so competently? Stephanie, do you have a lot of experts on staff that make those determinations?
That's an interesting question. The answer is I don't know. A lot of the questions here, I think, are they're very good questions, and it's a good question that was raised. I don't know how that would happen. What I can say is that I have an entire team, a Fed Funds team, in the Division of Legal Services alone. They're within the Department of Administration. We also work very closely with the State Budget Office, with the Governor's Office. We work closely with state agencies, all the state agencies, their fiscal departments, their attorneys. So there are a lot of people involved in making these decisions on the state side. I don't know how the legislature would kind of staff on their side. I don't know, but I can certainly say that there are a significant number of people who are helping to not only administer these programs, but ensure that the grantees are in compliance you know, everything from that you can possibly think of, all the way from, you know, the attorneys writing grant agreements to the staff that I have that are sourcing data from state agencies and reporting it to the Department of Treasury. So it really, there's a lot of people involved on the state side, and I don't know how they would accomplish that.
Under these proposals, could federal funds be lost during periods when the legislature is not in session? For example, the legislature adjourned in March and it's not scheduled to reconvene until January of 2025. Are you able to address that, Stephanie? And perhaps Professor Oldfather could too.
So another good question. I think that this kind of harkens back to one of the questions that I answered with Joan, which was, you know, would there be delays? I think the answer is certainly there. The possibility for delay is there. I don't know what that would look like, but they would certainly have to make, there would be a lot of kind of on the ground decisions that would have to be made. Now, if they went out of session, I don't know, right? What I can say is, depending on the source of the federal funding, for instance, like a competitive grant, they have application deadlines. And so, you know, in competitive grants, would that be affected? I don't know. You know, it all kind of is kind of a to be determined situation.
Professor Oldfather?
Yeah, I mean, I don't have a ton to add to that because I think so much of it depends on the particularities of the money that's at stake and deadlines associated with it and so forth. I guess the only other thing I'd add, and this really depends upon the partisan dynamics, but you know, it's certainly become, I think, more common to hear of states turning down federal money for, you know, political or ideological reasons in ways that, you know, probably didn't used to be quite as common. And so, you know, this would certainly provide an opportunity for that. One could imagine situations where a legislature would choose not to accept money that a governor might, and vice versa. But that's all fairly hypothetical.
Yeah. Someone wanted to know what exactly did the legislature have against the COVID relief fund that that Governor Evers was distributing? Was there something that they thought would need extra funding down the road, or what was the problem there? Professor Oldfather, do you know?
Well, I can't say that I've followed it super closely to know what the specific gripes were. I think part of it was just not being in the room when the decisions were made about how the money was allocated. I suspect there were critiques of specific ways in which it was allocated as well. Obviously, COVID and responses to COVID were ideologically charged, so I'm sure that had a lot to do with why they were unhappy in the way things unfolded.
Are you seeing even around the country, or how does Wisconsin fare here in terms of how many times do you amend a constitution because you can't get a state law bill to be signed by the governor?
Well, I think the answer to that is that it's less common here than it is in many other places. There are some state constitutions that have been amended hundreds of times over a much shorter period of existence than the Wisconsin Constitution. So, you know, whether it's been a result of a generally functional government or of norms against amending the Constitution in these sorts of ways, there's been less of it here, and in some places quite a bit of it.
Here's a question for Bryna. When it comes to language, someone wants to know, does joint resolution language usually get developed in committee, and does it take a simple majority to pass it?
With talking about the constitutional amendment process, yes, it's a simple majority. I think it's drafted sort of by the authors in tandem with the Legislative Reference Bureau and legislative attorneys, and then it does go through a committee hearing process. If the question is referring more to the approval of funds question for joint resolutions, I'm not sure exactly what that process would look like again, and I think it's more likely that the legislature would pass some sort of legislative rule for passing federal funds so that they don't have to actively pass a joint resolution to accept every type of federal funding. And I think that really gets to, again, sort of going back to what Stephanie was talking about, how much of this is in the details. You could imagine, or not imagine, there are states that have legislative review systems where they lean really heavily on agency staff, and they have mechanisms for approving funding even when they're not in session. But because we don't have any of that laid out in this amendment, we don't know what that process will look like or if those issues will be addressed.
Let's say we're referring to the language used in the amendment that itself, that the proposed amendment that ends up on the ballot. Does anybody look this over? A lot of people think it's just written in such a vague and confusing way. I mean, how is somebody overseeing that?
Yes, legislators are looking it over and talking about it, and the Legislative Reference Bureau looks over it, but ultimately they're sort of trying to stick with what the legislators are trying to do. Legislative attorneys look over it. But like I mentioned, sort of with California has this really robust explanation that is then provided, and our explanations are much more sparse. They kind of reiterate what the amendment says and don't provide a lot of additional context. So yes, there are people looking at this, and what the author said the goal was with question number 1, which is the one that's particularly ambiguous, is that the goal was to sort of keep the legislature from giving away this power in the future, because the legislature is the one that in the 1930s passed this law giving the governor power to accept funds. And so that was sort of his stated intent. But like I've said, it's not totally clear that that amendment accomplishes that goal.
A couple of questions on how hard is it to take something out of the state constitution? Chad?
As same process for putting something in. It has to pass 2 consecutive iterations of the state legislature and then gets put before the people on a ballot.
Yeah. So yeah, another question is just if they are passed on August 13th and become a part of the Constitution, can they be overturned in the future? Could be done legislatively, or could that happen in the courts as well?
Well, it would almost certainly have to be via a new amendment process, deleting the provisions from the state constitution. There are, in the abstract, some possibilities for challenges to the procedures by which the amendments were put before the voters, but none of those seem especially likely to lead anywhere in this situation. So we're really talking about if they're in the Constitution. Obviously, they can't be declared unconstitutional because now they're part of the Constitution, and so the only way to undo them would be to go back through the very same process that would have led us here.
Then again, somebody says if and when it comes to distributing the funds, if the legislature, if these amendments pass, it's in the Constitution, so therefore it's constitutional.
Right. Right.
Yeah. Let's see, we have so many questions I'm trying to see, and we only have a couple more minutes. If we had a different legislature, if with under fair maps, what if we had a legislature that we considered to be accountable, and a governor who didn't want to accept or distribute federal funds? Wouldn't wouldn't most people want the legislature or representatives who are closer to us have a say in it? Professor Oldfather?
Yeah, I mean, it's a great question because, you know, I think there's a real tendency, whether it's, you know, in reacting to court decisions or in considering something like this, there's a tendency to take the world as it is and not imagine the world as it might be down the road. And that's certainly, you know, a legitimate hypothetical and a situation that might well arise. And so, you know, we do always have to pause and ask, you know, try to remove ourselves from the specific situation that we're in and think about things more generally and more in the abstract. And, you know, again, as I mentioned during my main presentation, these sorts of rules matter most in situations where the branches of the government aren't on the same page. If you have single party rule in a state, these questions aren't coming up because things are getting worked out. People want the same things. It's all functioning as it should. Even in divided governments, you know, that are properly functioning, these things are getting ironed out and negotiated. We just don't live in that world right now. I hope we return to it someday, and sooner would be better than later, in my view. But yeah, I think you do have to think about that and think about, you know, is this the ideal solution for that world? Or is this a reaction to this world by the legislature? Not perhaps thinking 3 steps down the road either. You know, but those are certainly things for people to think about. I doubt that it's a question that would push the league off of its vote no position. You know, I'm not an employee of the state of Wisconsin, so I can say how I'm going to vote, which will also be no.
Thank you very much, Joy.
Great.
I appreciate your fielding all the questions in the chat. I'm sure we didn't get to all of them. Well, thank you. Thank you all for attending this important webinar. And thank you to our excellent speakers. We really appreciate you taking the time and commitment to be here tonight. If these amendments pass, they will change executive branch governance of federal funds to the legislature. And the league is really urging you to vote no and stop this power grab by the legislature. It's been there for 94 years with the governor. And we're concerned about the possible delays and denials of federal funds based on partisan interests. The few caveats before we leave tonight. Some people in Wisconsin don't have candidates on their ballot, but the amendments will be there. So please do vote on the amendments. And one other thing, the constitutional amendments are not labeled as constitutional amendments. They're labeled as referendum. So they could look and do look like a school referendum, which is really for current local issues, and school referendums change pretty regularly. Constitutional amendments, as we've just talked about, do not. They are then enshrined in the Constitution as of August 13th, if they pass. And please note that the constitutional amendments are at the end of the ballot, and the absentee ballots have them at on the reverse side. So please make certain you don't miss that as well. The stakes could not be higher for our state in terms of, especially when we need emergency federal funds. So my last comments are, now is the time to be mindful. Our Constitution is not to become the repository for a flurry of constitutional amendments with misleading and ambiguous language, trying to enshrine social or cultural policies or to enable legislative power grabs. Now is the time to vote no for these 2 questions on your ballot on August 13th. Thank you to each one of you for attending our webinar. A recording of the webinar will be made available to all local leagues after tonight. Thank you and have a good night.